Father Pavone have provided a wonderful service to the church, to the American people, to the Christian community generally, people of faith all over America, by pointing out, both by example, by publishing, by advocating the fact that as bad as the IRS is in terms of their rules and regulations, as vague as they may be, the church actually has way more ability to convey its message to its parishioners than some people are willing to allow it. And of course, he has pointed out in his book the fact that unfortunately many of the lawyers for the Catholic Church have provided advice that goes way beyond even the wildest imagination of the people for separation of church and state, as far as they would want to restrict the church in terms of limiting activity. An excellent example Father Pavone gave was the fact that the IRS has actually provided fairly specific legal advice on voter guides and what kind of voter guides a C3 organization can distribute. Even in the face of what is an area of very specific legal advice by the IRS that is widely relied upon and successfully relied upon by many C3 organizations to do C3 compliant voter guides, we still get advice from the lawyers for the Catholic Church that dioceses are not to distribute any voter guide except for one that is prepared by the church itself. I mean, that cannot possibly be based on any rational examination of the Internal Revenue Code, the IRS's legal advice in this area, but has to be based on some other agenda than legal advice from lawyers. That is one example. Another example is requiring dioceses and churches to run off of their public parking lots any volunteer that might come onto the parking lot to distribute literature. How possibly can a church be responsible for someone that they have no idea that is coming, didn't give permission to appear, and is doing something that is completely irrelevant to the church, and in fact is probably in some instances exercising their First Amendment right to distribute literature in a public place. In other instances might be trespassers. But how could that volunteer, unapproved, unknowing activity be the responsibility of a church? These are examples of advice that go way beyond anything that the IRS has ever suggested they would have a problem with. Well, but it's not that there's not a problem. And of course the problem is the vagueness of the Internal Revenue Service's interpretation of its own statute. But there is a silver lining as well. One that needs to be understood so that lawyers who seek to give legal advice in this area understand that there is way more latitude than the IRS's bluster, threats, and in some cases harassment. Well, of course it begins with the prohibition on political intervention. A C3 may not intervene directly or indirectly in a political campaign. And of course, what is intervention? It seems very, very broad and very vague. The IRS then adopted regulations where they could have given bright line guidance to what that means so that people in advance can know what they're to do or not to do. Unfortunately, they used phraseology that just compounded the ambiguities. He said that political intervention means, quote, influencing or attempting to influence, quote, an election for public office. And of course, the phrase influencing or attempting to influence is one that the U.S. Supreme Court in 1976 in Buckley versus Vallejo specifically condemned as being unconstitutionally vague and required and put a interpretation on those words to apply only to certain communications that would, by their express terms or in explicit words, advocate the election or defeat of a clearly identified candidate. Well, despite that interpretation, despite that narrowing gloss that the court gave on those words, the IRS has been adamant that they will not adopt a bright line test, as the U.S. Supreme Court said in 1976, is required under the First Amendment, is required by the Constitution of the United States, and that they will insist upon what they have termed to be a facts and circumstances test, one in which the facts and circumstances of the communication will be looked to decide whether or not it is political intervention. Well, pointing to the facts and circumstances really doesn't tell you what facts, what circumstances are relevant or pertinent. And of course, it would be the facts and circumstances. Obviously, it wouldn't be the astrological signs, that people would look to decide whether or not a particular communication intervenes in a political campaign. Obviously, it would be the facts and circumstances. So telling one that tells one nothing about what it is those standards are. Well, they have, as I have mentioned, given advice through various revenue rulings. They've been given fairly specific advice in 2 revenue rulings regarding voter guides and voter educational material, ones that have proven to be fairly, the groups have been fairly successful in following and adhering to. And as a result, many C3 organizations, including churches, do voter guides that are perfectly acceptable for distribution at any church in the United States. They have done some revenue rulings on candidate debates, both by not-for-profit organizations and by media outlets. And again, these seems to have been fairly successfully adhered to, and made because of their specificity. However, with respect to communications generally, we really have a problem. In 2004, they issued a revenue ruling reiterating the fact that they have no bright lines, that they will use the facts and circumstances test. And in 2004, that revenue ruling applied to C4, C5, and C6 organizations. They identified 6 positive factors that one could look to see whether the particular communication was political intervention or not, and pointed to then also 5 negative factors, one of which was the absence of any positive factor, as if you could have a circumstance with no positive factors, but it still be considered political intervention. Then in 2007, they issued another revenue ruling. In this case, it addressed a broader category of types of political speech, but when they got down to communications, they had 3 scenarios, and they identified, specifically identified 7 factors that they considered to be relevant to this consideration. Remember, 3 years before they had 11 factors. Now they're down to 7. 4 have somehow or another disappeared. And one of the new factors, there was actually a new factor that they introduced, one that they said was the most important factor. One that was not even mentioned 3 years ago becomes 3 years later the most important and relevant factor, and that is proximity to an election in terms of the communication. So They didn't tell us, though, whether the one in 2004 has now been superseded by the one in 2005, or we'd add these all factors together, mix them up. They didn't tell us how many of these factors had to be present, either positive or negative, what weight they would give to any individual factor, and it just became perfectly obvious that this is a exercise in pretend to give legal advice as to what you can do, because what you will be judged is ex post facto and ad hoc in terms of their determination after the fact, whether or not you've engaged in political intervention. Of course, at the same time, we were experiencing, I was representing the Christian Coalition, and it took them 9 years to decide that the coalition was not actually a C4 organization, using these very vague standards on whether or not an organization complies. They were sued. As soon as they got to court, bingo, they're writing us a check to send back the taxes that they had assessed against the organization. And when the judge said, well, that's not enough, they still are entitled to their exemption for the years that were challenged in court, the IRS said, well, of course, they were a C4 organization during those challenged years. In 3 other cases I've handled, we sued the IRS after they had imposed the tax and dragged the organization through the entire appeals process. We filed for the return of the, in each case, few $100s that they had assessed as taxes. 6 months after that is filed, on literally the last day of the last moment that we could then go to court, they issued a refund to the organization. In other words, the IRS is exhibiting a lot of tyrannical characteristics. They threaten, they bully, they drag you in some cases through administrative process, but they are loath to be subject to review by the courts. They know, as I know, that if they ever got into court with this utterly vague and hostile application of regulations to core political speech in the United States, that they would lose. So they literally move heaven and earth to make sure that they avoid accountability to the courts and to the Constitution. Now, when will they go to court or allow to be dragged to court? It's, in those 3 instances where everybody would agree you're intervening in a political campaign. You take church property and you give it to a candidate for his campaign. You're making a contribution to the candidate. 2, you have an assembly and you pass the hat for the candidate's campaign. You're using your church for a candidate's fundraiser. And 3rd, if the church, using church property, would endorse a candidate's election, advocate the election or defeat of a candidate. In those 3 instances, everyone would agree is political intervention. Those are the only instances the IRS has ever permitted itself to be dragged into court for review. In all other instances, and there's others that I have handled as well, where they move heaven and earth to prevent judicial review. So what does that tell us then about what we are facing? Yes, we are facing a demonstrably hostile IRS, hostile to political activity by the citizens generally and not for-profits specifically. We know that IRS is perfectly willing to engage in partisan enforcement of their political intervention regime, as demonstrated when they targeted the Tea Party organizations for specially adverse treatment who applied for C4 status in order to elect a particular person for President of the United States. We know that we have that type of organization, and we know that we have laws that they have instituted that are vague. But we also know that we have an organization that is fearful beyond measure of being held accountable in the courts and to the United States Constitution. So in that circumstance, if an organization, particularly religious organizations, believe that it is their calling to inform their flock of moral principles or obligations of civic participation, or of simply the public service of what is the positions of candidates on the moral issues that the church considers important, why would such an organization unduly restrict themselves when they know that they are dealing with an organization, despite all its bluster and harassment, will never, ever allow itself to be overruled by a court? Why would such an organization take these admittedly vague rules and take them beyond anybody's comprehension as far as restricting the activities? The moral teachings of the church are to be restricted because of this fear. Does anybody actually think for one instant that if one church, one Catholic church, say in my hometown, Zionsville, Indiana, would distribute a C3 compliant voter guide by somebody, let's say Catholic Answers, that has been specifically picked out as a prohibited voter guide, but does a C3 compliant voter guide, and I know that, I represented them, the IRS approved their voter guide, that if they distributed, because of volunteers going on to the parking lot of that church without the consent of the church, that the entire Catholic Church's C3 exemption would be revoked. Does anybody in their right mind think that that is even a remote possibility, even in the recently most hostile IRS that we've ever had in terms of its political, partisan political bent? It's ridiculous proposition, but it is one that is unfortunately seemingly motivating this restrictive advice. Well, there are ways of fixing this, and you will hear really two approaches. My approach is one that doesn't focus on the religious aspect, but focuses on the free speech and association aspect of all C3s. And that is that they are entitled to bright lines, not vague laws. And because we're dealing with core political speech, you're entitled, as the court has regularly said, to a bright line rule so you will know in advance whether what you say impinges on any rules. The Supreme Court has already said that influence has to mean, under the Constitution, expressly advocating the election or defeat of a clearly identified candidate. That works perfectly well in campaign finance rules, and it is the rule that ought to be adopted with respect to the Internal Revenue Service. The different second problem is whether or not the whole organization is to be considered political if they engage in some political activity. And here the IRS says if it's your primary purpose, and of course what they mean is they think an organization can have multiple primary purposes, and if one of them happens to be turns out to be intervention in a political campaign, well then the whole group becomes a political organization, which is what's called a 527, and of course there's consequences there. You've got to report all your donors, all your expenditures to the IRS in public filings, where C3 and C4 organizations, of course, don't have to do that, and their donors are confidential. So there are certainly consequences to whether or not you're a political organization. Well, that's a problem solved already by the Supreme Court in Buckley versus Vallejo and subsequent cases, which is it has to be your, quote, major purpose. There can only be one major purpose. What you spend more than 50% of your money on, that's your major purpose. And if it's political intervention properly understood, well then you can be deemed to be a political committee. Well, those would be bright lines that have been very successfully imposed because of the First Amendment and successfully used in campaign finance rules, both state and federal, all over the country. These are the very kind of rules the IRS should be following. The IRS should not be involved in deciding what is political. We've already seen demonstrably that they are incapable of doing that in a way that explains it to anybody, and is perfectly prepared to take a partisan approach to this question. That should not be their area of concern. Now you will hear about when we add to this whole dynamic the free exercise of religion.